Senator Henkel. Thank you, Mr. Speaker. Honourable colleagues, I rise today to add my voice to those who have already spoken on this bill and to raise two concerns about Bill C-12. I am also speaking because, like you, I have been approached by many credible organizations, including the Canadian Bar Association and several human rights organizations that are on the front lines of these issues.
Let me be clear. Canada must maintain an asylum system that is credible, well-managed, and effective. It must also process claims with rigor, within reasonable timeframes, and with responsible stewardship of public resources. Like any administrative system, the asylum process can be vulnerable to abuse. I therefore understand the government's effort to maintain its integrity. However, we must also recognize a fundamental reality. We are not talking about an ordinary administrative process. The asylum system exists because, in some circumstances, the protection we offer is the only one people have left. Canada's reputation for protecting those fleeing persecution is founded on firm legal foundations: the right to a fair hearing, the principle of non-refoulement, and an individualized assessment of each and every case. It is precisely in light of these fundamental principles that certain provisions of the Bill C-12 are of great concern. Ma première préoccupation.
My first concern relates to the one-year time limit for submitting an asylum claim after first entry into Canada. Under the bill, an asylum claim filed more than 1 year after arrival in Canada could be denied consideration by the Immigration and Refugee Board solely on the basis of time elapsed. In other words, Bill C-12 assumes that a person under threat would apply for asylum as soon as they arrive, without delay. However, this view ignores the complexity of migration routes and the fact that danger may arise after entry into Canada. A foreign student may see a coup d'etat break out in their country of origin. A journalist may become a political target after a publication. An LGBTQ plus person may be exposed to new threats following a change of regime. In all of these examples, the need for protection may not have existed at the time of entry into Canada. These cases may be few and far between, but it is precisely the honor of a state governed by the rule of law to provide a framework for these exceptional situations. There are also very concrete, humane reasons why some people may take time to apply for asylum. Fear of authorities, lack of language skills, or simply the difficulty of understanding a complex legal system. The date of entry into Canada has no connection with the existence of a well-founded fear of persecution. The 1951 Geneva Convention relating to the status of refugees does not set any time limit for submitting an asylum application. With the exception of the USA, no G7 country prohibits the consideration of a late asylum claim. a late filing may raise doubts about the claimant's credibility, but it does not close the door to the consideration of their case. My second concern echoes that of the organizations at the heart of the asylum process. It is a matter of fundamental principle. I repeat, it is a matter of principle. It concerns the replacement of the independent review by the IRB, the Immigration Refugee Board, with a simple administrative procedure, the PRRA. The proposed procedure does not offer the same guarantees. It is conducted by an official from Immigration and Refugees and Citizenship Canada and is based on the examination of a written file without a face-to-face hearing. However, no paper analysis can replace the opportunity for an asylum seeker to explain their story, to answer the questions of decision makers, and defend themselves the credibility of their own account. For the authorities too, it is essential to be able to assess certain key factors. For example, the political context, apparent contradictions, traumas experienced, all realities that often escape the simple reading of an administrative file. Above all, asylum applications must be assessed by an experienced authority that is impartial and independent of political power. Given these two issues, which I believe are crucial, I am carefully examining the amendments put forward to improve this bill. My goal is not to delay or hinder its adoption. I simply believe that it is the role of the Senate to amend a bill to make it fairer. It is then up to the other place to ultimately evaluate the suggestions that we have deemed necessary to make. Dear colleagues, responding to the legitimate concerns of Canadians about immigration while honoring Canada's legal and humanitarian commitments is the balance that we must maintain. It also reflects the values that we choose to remain faithful to. Thank you.